Breaking news out of Olympia. The Washington State Supreme Court has officially suspended the law license of Shannon McMinimee, as confirmed by Law 360, an attorney long accused of dodging accountability in two major student rights lawsuits. In a unanimous decision issued Thursday, June 12, 2025, the justices sided with the state bar's disciplinary arm, the Office of Disciplinary Counsel, confirming McMinimee's continued stonewalling of investigations required this suspension. The suspension is effective immediately. What led to this? Nearly a 2-year-long pattern of evasion, delay, and excuse-making. McMinimee, a current but departing school district attorney for the Bellevue School District, failed to turn over records, dodged deposition questions, and ignored multiple court-ordered deadlines until the Washington State Supreme Court itself stepped in.
Only after this court became involved did the respondent provide ODC with any records, responses, or releases.
Senior Disciplinary Counsel Francisco Rodriguez didn't mince words. At Tuesday's hearing, he told the court over a dozen depositions were scheduled, yet not one yielded substantive answers. According to Rodriguez, quote, "It was clear that only the threat of suspension motivated Ms. McMinimee to cooperate." The grievances stem from two lawsuits filed on behalf of students. One was dismissed after McMinimee failed to show up to court and ignored discovery requests. In the other, parents said she vanished entirely, stopping all communication. McMinimee defended herself at the hearing, citing the deaths of her father and husband during the investigation, as well as her struggles with PTSD and anxiety. She claimed she has, quote, "done everything asked," end quote, and that delays were caused by others. But the Supreme Court was not convinced. Their message? Cooperation with the disciplinary process is not optional, and accountability applies even to lawyers who represent the vulnerable. Now suspended, McMinimee can only seek reinstatement after meeting all conditions set by the bar. This is just the beginning. We'll be watching to see whether the embattled lawyer ever regains the right to practice again, or if this marks the end of the road for one of the most defiant attorneys in recent state history.
Hey everyone, I am free. It is June 10th, 2025. I am in the city of Olympia, here in Thurston County in the Communist Empire of Washington State. And of note, Olympia, for those of you not familiar with the area, is the capital for the Communist Empire of Washington State. So we're going to be heading over to the Supreme Court right over there, because Shannon McMinimee from here and here and here is actually in the midst of a disbarment procedure.
But before we go inside to see the show cause hearing, let's take a look at some of the interactions I've had with Miss McMinimee as I've covered stories regarding her and the Bellevue School District in the past. Shall we?
Gail, can you please contact Doug and alert him that we need to have law enforcement remove somebody from the premises?
Twitter account. No comment. Do you still have confidence in her adequately representing the school district with her past affiliations and her extreme pro-gun viewpoints?
Please turn your camera off.
That's not happening.
Okay, then you need to leave.
Did you let the board of directors know about your history as the president of the John Brown Gun Club? Do you feel like you're qualified to continue in your capacity right now?
This is not a building that's open to the public, and you don't have permission to record me.
Ms. McMinimee, do you have time for questions about your affiliations with the Puget Sound John Brown Gun Club in the past, with known domestic terrorist Willem Van Spronsen?
Whom are you doing business with?
The district.
No, you need to leave. Who do you have an appointment with?
Hold on a minute. You're counsels and you're an attorney?
I believe that the constitutional rights are constitutional.
Oh, so you do support?
But you do need to sign out.
All right. Appreciate it. Have a good day.
Scan out and you need to go.
How can I help you?
So I am here as a member of the press looking to cover the 11 o'clock.
Can I step around this way so I can
Sure.
just
Yeah.
goes back?
Yeah, no problem.
One more time, I'm sorry.
Yeah, I'm a member of the press. I'm here to cover the 11 o'clock hearing for
Okay.
McMinimee.
Okay.
So I know, generally speaking, they've got rules on recording, but they have allowances for press. What's the allowances around that?
Generally speaking, yes.
Is it good for me to just head on in there at this point then, or
Yeah, that's fine.
do you need to check with them first?
No, yeah, you can head on in.
Okay, cool.
There's
I'll
just-
take off my hat.
Yeah, thank you.
Yep.
be seated. Good morning. Welcome to the Washington State Supreme Court. Before the court is a show cause hearing in the matter of Shannon McMinimee. The way this works, we'll have a brief opening from the Office of Disciplinary Counsel Francisco Rodriguez, and then Shannon McMinimee will have 10 minutes, and then response by Francisco Rodriguez for 7 minutes. So please proceed.
May it please the court. My name is Francisco Rodriguez. I represent the Office of Disciplinary Counsel in this matter. The primary outstanding issue remaining in this matter is the depositions of Ms. McMinimee. To date, the respondent has not provided deposition testimony addressing the substance of these grievances, despite numerous opportunities to do so. Only after this court became involved did the respondent provide ODC with any records, responses, or releases. This morning, as I sat listening to the preceding oral argument, we finally received written responses to the grievances in these matters.
You mean via email or in your lap?
I received via email at approximately 10:08 a.m.
Thank you.
the responses from Ms. McMinimee. I have obviously not had a chance to thoroughly review those. With respect to the medical releases, as of yesterday, the respondent finally identified additional relevant providers and submitted appropriate releases to ODC. As to the records ODC subpoenaed, although the respondent claims to have provided all available records, the respondent has made inconsistent statements in this regard, repeatedly providing new records, some as recent as yesterday, after claiming to us and to the court to have provided all available records. We continue to question whether the respondents complied with ODC subpoenas and maintain that this issue needs to be further explored through deposition testimony. We also believe that only through the court's continued involvement through an order of interim suspension will ODC be able to complete these investigations. Based on the respondent's representation that there are no more records available, and now having received responses from the respondent this morning, ODC will move forward with scheduling depositions again. Indeed, we informed Ms. McMinimee that we would do so as soon as she provided responses, and yet did not provide responses until this morning.
Why will suspension make things go any faster than they have gone to this point?
We've scheduled over a dozen depositions with no substantive questions being answered about the grievances. We had no records, we had no releases until this court was involved. It's clear that whether it's the court's involvement or the threat of suspension, that is the only thing that seems to have motivated Ms. McMinimee to cooperate with our investigation. Should the court decline interim suspension, we'll be in exactly the same position we were before, with Ms. McMinimee postponing and terminating prematurely the depositions. And we'll have no recourse but then to petition the court again at that point for another interim suspension. At this point, Ms. McMinimee seems to have, the court seems to have Ms. McMinimee's attention, and an interim suspension is the way to continue that attention and get the depositions done. Pursuant to the court's show cause order, it is the respondent's burden to show why suspension is not warranted in this case. So unless the court has further questions, I'll reserve the remainder of my time for rebuttal.
I have one question. Do you have the releases that you are seeking?
Yes.
Thank you. All right, thank you, counsel.
May it please the court, Shannon McMinimee here on my own behalf. The parties do not dispute that under ELC 2.7.2A3, a lawyer may be suspended from the practice of law when the lawyer fails without good cause to comply with the request from ODC for information or documents, or fails without good cause to comply with a subpoena. I have provided ODC with everything it has asked of me. The last thing that Mr. Rodriguez asked of me was he asked for releases for every urgent care and emergency room visit that I have had, and I provided him with the addresses of all of those providers. Earlier in the week, he signed and returned the releases yesterday when they were provided to me by Mr. Rodriguez. I also had provided to him before that 4 releases for all of the medical and mental health providers that I've had since 2017 without any limitation, as well as providing him a report from a psychological provider that I saw for the purposes of obtaining that report. I provided him.
Did this all start in 2023?
Yes.
Okay, so just now, this week, you
I wasn't asked to provide information. I wasn't asked to provide releases for all of the urgent care and emergency providers that I had seen until recently. And as soon as that request was made of me, I provided Mr. Rodriguez with the contact information and then executed the releases as soon as they were provided to me.
So how come it's taken from 2023 to today to be here? How do you explain this?
Sure. I've experienced a tremendous cycle of personal loss involving, I apologize. I was a caregiver for both my father and my husband who passed away in 2023 and 2024 respectively. I also had my own health challenges, and the filing of the first complaint was concurrent with my husband's death, and I have struggled with significant PTSD and anxiety that is associated with that.
Do you understand the OEC's position to be that once they're satisfied with your compliance, that they will seek to have this court end suspension?
No. Mr. Rodriguez suggested last week that I seek to continue today's hearing so that he can schedule depositions, and I think that's an inappropriate course of conduct. I've done everything that has been asked of me, and I think the appropriate thing to do is for OEC to withdraw the petition or for the interim suspension order to be denied, because I am cooperating. If I have attended each deposition that's been scheduled to me, the statement there have been a dozen depositions is untrue, and I challenge Mr. Rodriguez to identify the dozen depositions he claims were held. I appeared at each and every deposition, and I'm not the one who terminated some of those depositions. Mr. Rodriguez terminated some of those depositions.
How many depositions have there been?
I believe 4, no, it could be 5.
And how many have you terminated?
I don't think that I've terminated any. I had a panic attack during 2 of them, and then had to take rescue medication that caused me to no longer be able to continue because it was impacting my ability to answer questions.
And the other 3?
Mr. Rodriguez, my perception of those was Mr. Rodriguez terminated those.
And how long did the 2 depositions where you had a panic attack last before you had ended?
One lasted, I would say, 45 minutes to an hour and a half. The other, difficult for me to judge the time on that.
Are there transcripts?
Yes. So I participated in one deposition where I had a cracked tooth and had asked for an extension to have, asked for the deposition to be rescheduled so I could get that treated. But Mr. Rodriguez did not have that, and I heard it and testified it.
So, Mr. McMinimee, I appreciate your candor to the court, and I'm very sorry for the losses that you've experienced. Part of our job here is to protect the public when there might be an attorney in a position unable to properly represent clients, and ODC has gotten involved, obviously, along to look at that question. I'm hearing a very different story from you than I've seen in filings, and so I'm just trying to understand what you. I think you answered this question when you responded to Justice Madison's questions, but I just want to be sure. What are you asking us to do today?
Dismiss the petition. Mr. Rodriguez does not withdraw it. I'm recognizing that I had.
I'm having a little bit of trouble hearing you. Can you?
Oh, sorry. To dismiss the petition if Mr. Rodriguez does not withdraw it, given that I have done everything that has been asked of me, and I cannot appear at depositions that he has yet to schedule. If Mr. Rodriguez moves forward to schedule depositions, I'm not sure if the basis would be non-compliance. That was the basis of the prior depositions. I've now fully complied. And so I'm not sure if he's continuing to seek non-compliance depositions, but that if I fail to participate in those, then it would be appropriate to come back and pursue an interim suspension order. But it's inappropriate to move forward with an interim suspension order when ODC has received everything that is asked for and when I have appeared in every deposition that has been scheduled for this matter.
Counsel, in light of the amount of time that it's taken, it does not seem unreasonable for opposing counsel to want to verify the things that you've provided to him at what seems like very last minute. So why is it inappropriate? Why is it more appropriate for us to deny the interim suspension than it is to have the bar counsel let us know that you are now in full compliance, which happens quite frequently, honestly, in my experience, is when the attorney does comply fully and ODC is satisfied, they let us know and they tell us that we can reinstate.
I would step back and say not everything was provided just in the last 2 days. I provided a substantial amount of materials before that. I have continued to provide additional materials, including every time ODC asked me for something that was not asked of before. I would identify that the basis for the issuance of an interim suspension is non-compliance, which I have now complied. So there is not a basis for an interim order when I have complied. And I think that that's the fundamental issue here, is it is not the court's involvement that has put me in a position to respond to ODC. I have taken the steps necessary to address my own disabilities that were impacting my ability to respond. I've addressed those, and I'm participating fully in this matter. And so it would be essentially punishment for the challenges that I have with respect to responding to ODC, rather than any effort to reflect compliance with the requirements of the rule that would allow for the issuance of an interim suspension order. Again, Mr. Rodriguez hasn't, I've attended every deposition that he has said. So to say that, I should be interim suspended pending depositions that have not yet been scheduled presumes non-compliance when there has been compliance.
Was ODC aware of your personal challenges over these last years?
Yes. I don't think it's disputed in the petition.
There were requests for accommodation, right, which
Yes.
were complied with. Are there any pending requests for accommodation?
I believe my last request for accommodation was granted approximately a week and a half ago.
From the request to ODC?
Correct. I think at this point, I've generally tried to share with you that to the extent that Mr. Rodriguez has raised consistencies with respect to my production of records, as I shared with him in depositions and written communications, I've used 3 laptops since 2018. I've provided him all of the materials that I have on those 3 laptops. One of those laptops had a motherboard hard drive failure, so I cannot access certain materials that predate when that occurred. And so to the extent to which those records don't exist anymore, I can't provide those. But I have provided everything that I have on all 3 of those laptops and provided to him the entirety of my communications electronically related to the matters at issue, and I've articulated what I cannot have access to because it's maintained by a firm that I'm no longer associated with. So I have fully provided him everything that I have. And I have gone beyond that and provided him things that he did not ask for. For example, I provided him with all of my firm's financial records from 2022 to present, minus of course the month of June, because I don't have those statements yet. I provided those even though they weren't requested of me because I am trying to be cooperative. So it would be fundamentally unfair to issue an interim suspension based on non-compliance when I have complied.
Further questions?
Yes. I just heard from opposing counsel a completely somewhat different story than what you presented. So I'd like to know at this juncture, what is it that she's non-compliant with that you asked for? Because you did read the part of the rule, good cause. So I'm trying to figure out what's the good cause for the interim suspension request. What is missing? What did she not comply with? What is
Well, good cause refers to whether or not she has a reason for not complying. But as far as the basis for the petition, I'm not sure specifically what your concerns are, but our main concern at this point is completing the depositions. We had tried again.
Well, I wanna find out about the depositions because your initial statements to the court indicated there were numerous depositions and she did not, comply with them. Her statements to the court were somewhat different. So what is left? What is missing? Why are you moving forward with this is what I'm trying to figure out.
Okay, I perceive two questions there. One is the number of depositions and what happened there. We detailed the dates that were scheduled and how they were rescheduled and the dates in which depositions occurred and why and how they ended up not being completed. We have transcripts. We welcome the opportunity to provide the court with the transcripts. However, they deal with a lot of Ms. McMinimee's medical information, and we didn't want to submit those in deference to her privacy. We welcome an invitation to present those under seal to fully explain what happened in the depositions and to show that Ms. McMinimee has not cooperated with our attempts to depose her and ask her questions about her new responses that we just received and about other information that we've gathered and the records that she provided. We subpoenaed her for deposition, and she has yet to comply with those subpoenas, and that is what we want to accomplish still, having now received most of the
Counsel, could you just directly address her recounting of the 5 depositions? Was that accurate, or do you have a different perception?
Oh, completely different perception.
Please share your perception.
I feel that it's not productive necessarily to go back and forth on it. We have transcripts. It's very clear what happened in the transcripts. And to the extent that issue is central to the court's decision, I welcome the invitation to submit those. In each
that's the reason you're here. You're concerned about future depositions. That's what you said in your introduction.
Yes.
It's hard for, at least for me, to make that determination if I don't have an accurate history of maybe how the other 5 went, whether there's been cooperation or not.
Well, we presented our explanations in our petition, and they didn't seem to be contradicted until we arrived here for oral argument today. Had that been a major issue that Ms. McMinimee had raised, we may have sought a motion to file those transcripts under seal as part of our reply. However, it's only now that it is becoming the suggestion that I am, for some unknown reason, terminating depositions that I want to take place, which just sort of doesn't pass the test of making sense. With respect to some other things, with respect to records, we received almost no records regarding the Martin case. We received no notes from these cases that were in litigation for long periods of time. We received no accounting of Ms. McMinimee's work on any of these cases, despite her telling us in the deposition that she's taking this, keeping track of this, and she needs to do so to collect her fees. And so we question whether or not she has provided all records and do not believe that she has shown that she has. With respect to the recent accommodations she got granted, she asked to be able to deliver records to us via USB drive versus uploading them to a secure server. That is the accommodation that was requested. Nothing that relates to anything at issue here today. With respect to the medical releases, our letter is in the filings. We requested all this information originally in our letter. This is not a new request, and yet Ms. McMinimee didn't comply with it until yesterday. This is a consistent pattern.
I want to put you in a position of having to provide information that's private and personal and so on. But was there ever an effort to, in your view, on the part of Ms. McMinimee to work with the bar as far as the personal issues that she had been encountering?
When we learned of these things and Ms. McMinimee requested extensions, we granted the extensions. The deposition issues with scheduling often had to do with her work schedule for the Bellevue School District, and issues that arose at the last minute, whether they were related to medications or symptoms being experienced during the deposition, such that the depositions couldn't go forward in any meaningful way. And it was always Ms. McMinimee's request for each of the depositions that they not go forward. This was not something where we unilaterally decided we'll just abandon this deposition that we want to complete. There's great expense and great time involved in preparing for these depositions. We had no desire to have drawn out 5, 6 depositions in a given case. We want to complete it in one sitting if at all possible, and that simply hasn't been possible. If the court has no further questions, we would ask the court to issue an order of interim suspension because it is very clear on this record that the only time Ms. McMinimee has cooperated is after this petition was filed. And we have no confidence that we can complete the depositions without the intervention of this court.
I actually do have one question, if I might. If an order of suspension is granted and Ms. McMinimee complies with the depositions that you schedule and you're convinced that she has supplied everything, would you be informing the court of that so that we know, so that we can make a decision on whether the interim suspension could continue?
Of course, in that instance, typically we either support or don't oppose a motion to reinstate.
Thank you.
All right, thank you, counsel. I want to thank both Ms. McMinimee and counsel for ODC for your arguments this morning, and the board is adjourned.
All rise. The Supreme Court is adjourned.
Ms. McMinimee, do you have any comment about it took 2 years for you to respond, whereas just the other day you finally got those documents in, and why it's being alleged that you didn't respond to a ducis tecum? Why did you not respond to that subpoena until literally just the very last minute? I have multiple sources that are now reporting that you have been bullying them, that you have been dragging things out to cause issues, and it seems like this very issue right here, dragging things out as is being alleged by the ODC, seems to comport with what these sources are saying about your behavior towards them. Do you have any comment about your departure from the Bellevue School District? Why has it been going on like this for 2 years? Excuse me, sir. Do you have any comment about the hearing today for Ms. McMinimee? Were you also aware of the fact that she used to be general counsel and president of the Puget Sound John Brown Gun Club and was close personal friends with Willem Van Spronzen, who committed a terrorist attack against the ICE detention facility?
I don't have any comment.
Were you aware of that?
I don't have any comment.
Is there something that's preventing you from discussing that issue? Is it germane to what's going on right now?
I don't have any comment.
Is it common for the ODC, for the Washington State Bar Association, to have attorneys continue in their practice in Washington State when they have such close affiliations with known domestic terrorists?
I don't have any comment.
Do you think that this is going to work with the interim suspension?
I don't have any comment.
No comment at all?
No.
I mean, you're making the argument in court. How long of a suspension do you think would be necessary to get her to comply?
I made all the arguments and all the comments I'm going to make on the record before the court.
Is there something that you're concerned about if you make a comment now it's going to jeopardize your case before the Washington State Supreme Court?
I don't know how many ways I can say I don't have any further comment.
We seem to have a lot of comments by filings. There's nothing else that you can answer. There's a lot. I've got sources from the Bellevue School District. I think possibly some of them were in there today who are alleging at least, have been seriously bullied by Ms. McMinimee, and her track record of seemingly dragging things out for prolonged periods of time seems to track with exactly the same kinds of arguments that you're making in front of the Washington State Supreme Court. Were you aware of any of those bullying, harassment issues that are being alleged by people?
I have no comment.
We appreciate your concern, but we're not going to answer any questions. But thank you.
All right.
Best of luck to you. Thanks.
All right, well, that was the hearing there today for in front of the Washington State Supreme Court. That's ODC from the Washington State Bar Association asking for an interim suspension against Ms. McMinimee to get her to comply with the subpoenas, ducus tecums, as well as depositions and whatnot. I can say from my having worked 3 stories now regarding Ms. McMinimee, and these sources alleging that there have been tactics of bullying, harassment, intimidation from Ms. McMinimee, that it seems to completely track with what we just heard in court today in the Washington State Supreme Court. I don't know why counsel over there has no response. He seems rather vociferous, committed to his belief that she is just dragging things out. And from what I'm hearing from sources, this completely seems to be true with what Ms. McMinimee is trying to achieve, which is drag things out, make it a punishment, make the process the punishment, so that people will eventually just give up and, you know, withdraw their complaints, retract their complaints wherever they're filed at or who they are filed with. So that's going to be it here reporting today at the Washington State Supreme Court. That was an 11 o'clock hearing for the a show cause hearing as to whether an interim suspension, which is being requested by ODC here in Washington State against Ms. McMinimee's bar license, will go forward or not. It was an interesting conversation inside with the questions being asked by the Washington State Supreme Court justices. Some of them were a bit on the fence, it seemed like, as to whether or not this is even going to be a worthwhile process. However, what the counsel said for the Washington State Bar Association is that it wasn't until yesterday where most, if not all, of the records were actually produced right before the hearing. And so the interesting argument here by counsel, of course, is to say, do we need to do this for another year or two and cause more issues with getting this justice process resolved, just so that he has to come back and file to, in effect, threaten, if you will, Ms. McMinimee with her law license to get her to comply again? That kind of a response could drag things out for years, and at this point it already has been years where this has been going, as ODC said there. So that's it here reporting today in front of the Washington State Supreme Court. Beautiful day here at the Capitol in Olympia in Thurston County. If you like my journalism, don't forget to like, share, and subscribe. Hit that all notifications bell so you can get my stories right in the release. You can follow me on X at I.A.M. Free Auditing, on Facebook at Inland Auditing Media. If you want to help keep my feet on the streets, you guys know what to do. You can go to the links in the description for Cash App and Venmo. Thanks for watching. Thanks for supporting my journalism, and I'll see you guys at the next location. Bye for now.
Oh!
Bye.
Well, congratulations. If you have stuck around this long, you are going to hear the exciting and fantastic world of search engine optimization, keywords and phrases being stated by me. I'm trying this new approach in an effort to see if it will help reach new people who have not seen my content. So thank you for sticking through all the way to the end for this very exciting SEO keywords and phrases audio clip. And remember, if you support government accountability, realize you do not need permission to record in public, and support this journalism to catch we the people's public servants violating your liberties, you can join the movement by standing up for your rights by using your camera for protection. Remember, do not let someone else's feelings override your constitutional liberties. First Amendment audit, First Amendment auditor, cop watch, filming in public, public photography, police audit, civil rights audit, constitutional audit, filming cops, public employee accountability. Freedom of the press audit, government transparency audit, cop gets owned, tyrant, cop exposed. Public official meltdown, unlawful detainment, cop violating rights, do not talk to cops, police fails audit, detained for filming, illegal arrest caught on camera, tyrant exposed, shut down by the law, cop loses it, Karen meltdown in public office. Police accountability, law enforcement transparency, government employee misconduct, qualified immunity, badge number refusal, unlawful search and seizure, rights violation, abuse of authority, refusing ID, public records access, FOIA request audit, know your rights, what to do when detained. Filming police legally, recording in public law, First Amendment rights explained, how to file a complaint against police, legal to record government workers, public sidewalk rights, is ID required by law, open government laws, can I film in City Hall, must see police encounter, unbelievable cop behavior, you won't believe this audit, epic audit fail, gone wrong audit, never seen before reaction, wait for the end, triggered public official, body cam footage released, he regrets confronting this auditor, City Hall audit, police station audit, courthouse audit, DMV audit, public library audit, Sheriff Department audit, post office audit, federal building audit, public park audit, fire department audit, school district audit, reasonable articulable suspicion.